The Federal High Court in Abuja will decide on January 30, that's today, Omoyele Sowore's application for bail in a case instituted against him by the Inspector General of Police over alleged cyberstalking. The judge gave the date after hearing the submission of counsel from both sides for and against granting the online publisher bail. Sowore's counsel urged the court to admit his client's bail owing to his being a former presidential candidate. The counsel for the Inspector General of Police urged the court to refuse Sowore's bail. He was then remanded in police custody.
I rejected the administrative bail of the police because I cannot, in good conscience, continue to participate in illegality. The courts have made it very clear that the police have no right to grant administrative bail that asks for civil servants to own, first and foremost, 100 million naira houses, which is a crime. That's corruption. To stand bail for me, who is an employer of labor. I'm a publisher of an internationally renowned news website. I have people who are hired in Nigeria and abroad. I'm not a civil servant. In fact, I'm an uncivil citizen who is against all kinds of corruption, and I've spent my entire life fighting against corruption. So to now ask me, to insult me that I should provide a level 17 director who had not, who had not gotten employment when I was fighting for democracy in 1992, to now ask the president to come and stand surety for me is the biggest insult.
Section 367 of the police regulations prohibits the filing of a charge of this nature by a police officer who is using the instrument of his office as a tool of settling personal vendetta. The said section 367 of the police regulations prohibits the IG from using his office. This is an abuse of prosecutorial powers by the police. This charge, we repeat, should never have been in the first place. And this charge must be withdrawn by the AGF. We will ensure that we raise the appropriate petitions to the office of the AGF. Section 174 of the Constitution vests in the AGF the power to prosecute and undertake all criminal prosecutions in the country in the AGF.
Well, joining us now on the show is Marshal Abubakar, Omoyele Sowore's legal counsel. Good morning and welcome on the show.
Good morning and thank you for having me. It's a pleasure. Thank you.
Well, Marshal, we just listened to you about the Sowore case with the Inspector General of Police. Well, if you could just, for the benefit of our readers, of our viewers, restate the facts of the case and what the next steps are likely to be on your side.
Well, you see, Mr. Sowore was invited via a WhatsApp message by the police, the office of the DIG Ladanchi, for interview over a video he allegedly posted on his social media handles, where he alleged he exposed corruptions and refused to what they call obey lawful orders by policemen. In that video also, you will see, I cannot vouch for the veracity of the video, the authenticity of same, but you will see in that video that the police officer even asked Sowore to go upon recognizing the person of Mr. Sowore. Now, when we went for the interview at the police for the first intelligence bureau, the DIG Ladanchi interviewed us, and we simply asked the question that you are alleging that a crime has been committed in connection with that video. Can you tell us the nitty-gritty or the basics of that particular allegations you're making? What is the venue, even for a start, what is the venue or the location of the particular offense you alleged was committed? They could not offer an answer. So when they saw that apparently that story would not scale and that a charge on that premise would fail, they decided to dig deep by looking for some other things to charge Omoyele Sowore with. And you could see a 14-count charge was filed a day before yesterday. 16-count charge was filed a day before yesterday by the police, where they alleged that Mr. Sowore cyberstalked the IGP by calling him an illegal IGP. Illegal IGP Egbetokun should resign. I regard that particular charge as most laughable. Firstly, it's an abuse of prosecutorial powers. Secondly, in a sane society, such a charge should never hold. As a matter of fact, filing of that charge by the IGP is sufficient ground for the President and Commander-in-Chief to relieve the IGP of his office immediately. Because Section 367 of the police regulations, Regulation 367, clearly prohibits any police officer from instituting a legal proceeding in matters that connects to his employment or his interest in office. That charge that was filed by the office of the IGP in his own name clearly violates these regulations. And the police cannot, no police officer can act in violation of the law that guides their proceedings or that guides their work and duties. It is also clearly a breach of Section 174 of the Constitution that vests in the AGF the power to prosecute. The IGP has simply used his office and the instruments of his office to abuse, to covet for himself prosecutorial or abusive powers of prosecution. This charge will retreat. If you see the entire 16-count charge, we are all hanged on cyberstalking the police. And mind you, they brought that particular charge under Section 24 of the 2015 Cybercrime Act and the 2024 amendments. That particular section has been amended, in so much so that using that particular section as a tool for ventilating personal vendetta or for settling personal scores has been expunged completely from the particular law. There are judgments which you've cited to them, judgments that has prohibited the police from filing charges under the Cybercrime Act to settle personal scores or personal defamation or using it as a tool to settle personal scores against individuals in Nigeria and persons in Nigeria. The police has no powers under that law to file a charge upon allegations of defamatory comments made by a Nigerian against any person, including the IGP. So that charge in the first place should never have been. But because we live in a country where we are, they just believe they can act recklessly and do things that appeals to them. It should never have been. We would ensure that upon the consideration of the bill of Mr. Sowore today, we take all necessary steps to ensure that that charge is withdrawn and that appropriate sanction is meted out to the IGP. What he has done is simply to abuse his power and his oath of office, and that should never have been allowed in a democracy like ours.
All right, I believe you can hear us. Okay, Dr. Batu, you're going to ask him a question? Or?
No, please go ahead.
All right, okay. So let's really examine this Cybercrime Act, and I'm glad that you pointed it out and how it's been misused or said to be misused, especially by the police. Only recently, in the Dele Farotimi case, it was struck out by the courts when they also, based on a petition by a private citizen, the IG of police had also charged him, had petitioned the court for using the Cybercrime Act. Now, in this case, they have also said that cybercrime, he's gone against the provisions of the Cybercrime Act. Do you think it's time for us to either do away with this act or go back to review the provisions of this act, as it has been used in many instances, as in this case, to address personal vendettas or personal infringements or challenges?
You see, it's so sad that, you see, the idea of criminalizing free speech in this part of the world is something that should never have been. The world has moved beyond these relics of colonial laws that the British introduced to this country to impugn on civil liberty and the right to freedom of speech. The entire world today, Nigeria is the only country, I think in Africa, or even in the world today, where you see that the police has made an attempt to criminalize free speech in the country. The right to speak freely includes the right to say things, including that which you find very offensive, including the right to say things which you find not appropriate, including the right to say things which you find offensive. If somebody says something to you which you do not like, the only action known in a civil society, or the only actions that is available to you, is to file a suit under the thought of defamation. But unfortunately, the Nigerian police, for whatever gains they intend to benefit from this particular Cybercrime Act, has retained the power, wrongly quoting Section 24 of the Act to include the right to criminalize free speech. Globally, As a matter of fact, it has even been stated and held in several authorities and in several judgments by the court in the land that the right of Nigerians to dissent, to air their opinions on matters of public importance is a right that derives directly from the Constitution, and that the police or the government or persons that occupy public office has no right to use the instrumentalities of the Cybercrime Act to annihilate and oppress persons or the media who engage in this right to freely criticize the government or government policies.
Mr.
So
Marshall.
we strongly believe that the Cybercrime Act should be abolished completely.
Mr. Marshall, yes, and there's
so
a
that
lot,
Nigerians can freely.
Mr. Marshall, and there's a lot of talk as regards the abolition of the Cybercrime Act, because we've seen a lot of high-handedness, and that's the go-to way for the police when they want to commit their nefarious activity. We also have the case of the lady that Sowore even brought that story out to the limelight about the lady that swore for a police officer and she was kept in incarceration since God knows when. That case is another case that is ongoing now. But I want to ask you the logicality of the level of madness that goes on in this country. Please, maybe because, a lot of people say we are mad in this country. Maybe you can make sense of the madness. How can you bring a man in for a case of a video, and now you have gone to a Cybercrime Act, and you are saying they abuse the IG, and a court in this country even accepts that in the first place, and even accepts it for hearing? What you invited Sowore for was for a case of he challenged a police officer, and in the video it was clearly stated when the police officer asked him to go. And now you change the matter to a Cybercrime Act based on his tweets that had been made since God knows when. And a court accepts that. Are we not living in a very draconian gulag now called Nigeria?
It's quite unfortunate. And you see, I strongly believe that the courts in Nigeria are also complacent in this matter. And it's quite unfortunate that the police now has strong allies in this regards with the court system, which we're part of, unfortunately. You see, abuse or cursing is not an offense. Section 36 of Section 8 and 12 of the Constitution clearly prohibits the institution of any action or criminalizing any action that does not amount to an offense or a crime at the time such a matter took place or was committed. Under the Nigerian law, vulgar abuse can never be an offense under any law. There is no law that prohibits or criminalizes vulgar abuse or even laying of curses on persons. So when you see that the Nigerian states, or the police as it is now, the institution that has been bastardized by the persons who has an interest in bastardizing it, using this instrument of states to annihilate and to punish persons who simply engage in matters that should have been instituted in a civil action for defamation of character of such persons, that is if they have that character in the first place. When you see all of these actions taking place, all of these scripts that they are playing out now, then you know that we have a long way to go in this country. These persons are strongly bent on further desecrating and destroying the institutions of state in this country. And Nigerians have to rise up and challenge this impunity. We can no longer continue like this, where you stay in the country where the strong men, in quotes, in the country continually perpetuate themselves and use the instrument of state to oppress and to gag Nigerians. Suffering in this country today is public knowledge. Even a child born today knows that there is pervasive poverty and hunger in the land. Now, these people will decide to beat Nigerians by subjecting them to hunger, to deprivation, to inflation, to lack of basic social infrastructures. And for the few that dare to complain, they hand them in court, put them in chains, take them to prisons, and stop them from speaking. And because they have strong allies in the courts, they have some judges whom apparently are their friends. They run to this court and get injunctions and get orders to annihilate and to put these people of goodwill and character behind bars. This clearly has to stop, and Nigerians have to rise and challenge the status quo. Unless Nigerians come to the fore and take the gauntlets and seize the country and take charge of the country. The Constitution of Nigeria in Chapter 2 clearly declares the people of Nigeria as the true sovereign. Sovereignty is derived from the people of Nigeria.
from whom government, through the Constitution, derives all its powers and authorities. Enough is enough in this country. We must rise up and say that this is our country. This is our common patrimony. We have nowhere else to go to except this country. And once we allow these persons to continue to perpetuate themselves in power and to abuse their oath of office and continue as unchallenged, then we are doomed in this country.
Well, thank you very much for your time with us this morning, Mr. Marshal Abubakar. I will look forward to keeping up to date with the outcome of this particular case. Thank you.